Welcome, everybody, to the Psychedelic Support monthly speaker series. It's our last one of 2022, and I can't believe that this year has flown by already. And I can't think of a better topic than to close the year with the legal landscape of psychedelics. So much has changed this year, and for sure, the look ahead is going to be lots of unknowns and new developments that we're going to be hearing from our expert panel of attorneys that specialize in different areas of law. We had a lot of questions submitted through the registration link that we're going to be addressing many of these questions. If something comes to mind, you can also pop them into the QA here, and if we can, we'll get to those questions as well. We encourage you to chat with each other in the chat, say where you're coming from, say hello. This is meant to bring people together, share ideas. If you have resources, links, questions, comments, that can all go there in the chat. Thanks for being here, and I'm going to turn it over to Adriana for introductions.
Excellent. Thank you, Ali, and thank you for inviting all of us to be here today. It's really, really a symbol of how we at Plant Medicine Law Group have approached this conversation to pull in people that are really the experts in certain fields or becoming the experts in certain fields. So without further ado, Plant Medicine Law Group is a corporate law firm at the forefront of psychedelics and cannabis law. We are active in the states of New York, California, Pennsylvania, Washington, D.C., and Oregon. And since beginning operations in November 2020, we have actively explored how psychedelic law and healthcare law overlap. And in the process, pretty early on, we met Harry and developed a relationship with him and his team. And we always say that it's a constant exercise in humility to figure out what are aspects of psychedelic law that a law firm like ours, which is a generalist law firm, generalist corporate law firm, can handle and can create an expertise. And where do we really have to raise our hands and say, you know what, these topics, this analysis really, really has to sit in the realm of healthcare law with an expert like Harry. And so we've been in active conversation with him, and then now in Q1 of 2023, we are adding a healthcare lawyer to our team, which is really a symbol of where the industry is going. Hadas Alterman was a founding partner of Plant Medicine Law Group and is now Director of Government Affairs at the American Psychedelic Practitioners Association, also known as APA, and Hadas will have a chance to talk more about what the organization does. She's also a founding member of the Psychedelic Bar Association, and there in one intro, you've already heard the name of two important psychedelic infrastructure entities that Hadas is very active in the creation of. Harry Nelson is the founder and managing partner of Nelson Hardiman and is a leading expert on healthcare and life science legal issues. Harry is passionate about making sense of complex topics and navigating the way forward for healthcare organizations, government, employers, investors, and the public. He's also an author. And when he introduces himself a little further, I'm going to ask him to give names of his publications. And so without further ado, I'm going to ask for both panelists to give a little bit more information about their organizations. Hadas will also give an overview of what is happening in Oregon and Colorado, since I know we're all interested in the rapid changes taking place in those two jurisdictions. And then I'll dive into moderating the questions that we receive from the audience. The reason we ask for questions in advance is because we don't want to be seen as giving legal advice to specific individuals. So we've received questions, Ali has filtered them, and we are neutralizing any kind of specific information about the person, place, or thing so that we can give general overview and not be seen as giving legal advice when we shouldn't be. So, all right, Hadas, I'll toss it to you.
Cool. Thank you, Adriana, and thank you, Ali and Psychedelic Support for having me and for hosting this panel. So just a little bit of background on what I do. I'm the Director of Government Affairs for the APPA, the American Psychedelic Practitioners Association. We're the organization that's been mandated to safely integrate psychedelics into the US healthcare system. So what that means is that we're creating professional practice guidelines and standards of training, and then actually working with federal decision makers to have them adopted. So eventually we can have APA accredited training programs to teach board certified psychedelic practitioners to provide quality clinical care. And that will enable beneficiary reimbursement as well. I think in terms of what's happening in Oregon and Colorado and an overview, those pieces will come up in the questions. There's so much to be said. They could each be panels on their own. But very briefly, both of the states have passed, and Oregon is now implementing supported adult use models. So licensed facilitators guiding psilocybin journeys, essentially, for adults over the age of 21. It's not a medical model in either state, and we can get into all of the details of what that means when we go through the questions.
Excellent. Harry, on to you.
Terrific. Well, at first, I want to thank you so much for including me. It's really an honor. And I'll come back and I want to I guess maybe it's useful if I talk a little bit about our firm and what I do, and then I'll come back to why I think the work being done at Plant Medicine Law Group and APPA is so important. So my background is I've been practicing in healthcare and life sciences for about close to 30 years. And I started off my career in an work at a law firm in Chicago that did work for institutional healthcare, mostly teaching hospitals and academic medical centers. And it was a great place to learn the landscape of healthcare and life sciences in a very conservative environment. And then I came out to California about 20 years ago, and I started a small firm with an individual practitioner whose work was really representing providers, particularly physicians and mental health professionals who were getting into trouble with government agencies. And it was like a flip to a very different piece of the compliance landscape. And I spent my career, and what we do as a firm is really trying to distill out the lessons from continuing to be involved in crises in a lot of different parts of healthcare and life sciences and government enforcement to give practical advice. And I've always been drawn to areas of innovation, but I think I bring, what we try to do as a firm is we try to bring the learning from all these different parts of healthcare, which you start to see a lot of connected dots from one sector to another, and to apply those to areas where there's a lot of innovation. But it makes me really grateful for people like Plant Medicine Law Group, for like Adriana and Hadas, who are just really dedicated to the space, because the challenge of being in a lot of spit conversations is it's very hard. The ground is changing so quickly, and the regulations and the landscape legally is changing so quickly that it's really important to have dedicated specialists. But I hope we add a little bit of rounding out of some of the way that the intersection with healthcare and regulators, how that's likely to play out. I also just want to say I'm grateful to everybody listening, and in particular, I want to give a shout out to Christy Meyer at Flow Integrative, one of the pioneers here in Southern California that we've been privileged to work with, and so excited to work with the people who are really pioneering this transformative area of healthcare.
So what I love about this introduction is that we already start getting a sense of just how much things are in flux, just how much is new, just how much is areas of the law that have to figure out how they come together. So, and also I think one of the things we'll touch upon in our discussion is the importance and the difference of what are best practices and what is the law, right? And sometimes those things are quite different. So without further ado, maybe Hadas, you can take a crack at this first question, which is, do you have any advice to healthcare practitioners practicing in the underground? Depending on jurisdictions, are there leaders in the field? Are they leaders in the field, or are they the next to get arrested? Is this question. What are some precautions that people should take to preserve their livelihood? And I'd add their licensure?
Thanks. So I think it depends on what you mean by practicing in the underground, like specifically what it is that you're doing. It's not legal to administer Schedule I controlled substances to your patients. I think that there's some useful precedent here to consider from cannabis, but it's also important to keep in mind that that comes from, medical cannabis in states where that's legal. But I think it's still helpful to talk about. So the Ninth Circuit has held that the federal government can't punish or threaten to punish a doctor just for telling a patient that it's suitable to use cannabis. Of course, it's illegal for a doctor to aid and abet a patient to obtain cannabis or to conspire with them to do so. So you see what the analogy would be here for other Schedule I controlled substances. But the court drew the line between protected First Amendment speech and prohibited conduct in a couple of ways. So a physician can discuss the pros and cons of cannabis with a patient. And they can also issue a written recommendation for cannabis if you've got a bona fide patient-doctor relationship without fear of legal reprisal. But that's not really relevant to psychedelics, right? Because we don't have the same, medical cannabis model. So I think, the distinction that's helpful, or the line that's helpful to draw between cannabis and psychedelics here is that you can talk to your patients about what psychedelics are, right? And that wouldn't be considered practicing in the underground. I would say, if you're thinking about states like Oregon or states like Colorado, I know not everyone here lives in Oregon or Colorado, but those are the models and the regulatory frameworks that we're going to see in a lot of other states that allow for these supported adult use models. And they will have sort of pockets carved out where what is currently now underground work is going to be legalized. So Colorado, for example, it doesn't create any type of legal framework for psychedelic assisted therapy. And it doesn't create, a retail market for natural medicines or anything like that, but it does create a self-regulated community healing model by decriminalizing the personal use and possession, growth, transport of natural medicines, which they're defining as DMT, ibogaine, psilocybin, and I believe a couple of other things, mescaline. And so I think, in these states where there's decriminalization happening and there's supported adult use models happening, you are going to have more freedoms and less restrictions. But for now, and if you aren't living in those states, there's really not a whole lot you can safely do when it comes to administering medicine, or I would say legally do.
And Harry, since you have experience dealing with people who got in trouble, do you have any stories about licensed healthcare professionals that have, stepped over a line of a kind that would apply to this scenario as a comparison or an actual example?
Sure. Yeah. And a lot of the reference, I think the reference to cannabis is very useful, because I think that very much informs and shapes the way that the government is looking at this, and by extension, the way we as lawyers need to. And so, yeah, what we saw with, we've got a pretty well-established view now that doctors have some free speech right? That's also what underpins, in general, off-label use of FDA-approved medications. It's all about physicians have free speech, but I think that what is really dangerous is, and what we saw in cannabis, and I think will continue to be as long as substances remain on Schedule I, is being involved in the actual sourcing, of the medication. So what we what we saw early on from the DEA and also even at the state level was that physicians who took ownership and were getting profits from sales of Schedule I substances were at a very different risk level than those who were creating settings in which materials were being sourced independently and physicians were managing and monitoring. And again, and there's no problem with being kind of the manager, but once you put your hands on the substance, I think that's the danger. And I do think we're coming further because what we saw in cannabis was that the problem it created is that it made it difficult for identifying the sourcing and the dosing and the titration appropriately, and you really limit physicians when they don't have the same, and other health practitioners when they don't have the same level of control. But that, until we get a change in status, at least at the state level, remains the biggest risk issue. And I'll just add, I do think that it was a very bumpy ride in cannabis from the opening in 2009, when the DEA was essentially restrained by the Obama administration, to a kind of resurgence where the DEA, really tried to clamp down again, and then finally getting to the Cole Memorandum, where we have this fundamental principle now of federal respect for state policy. But I do think that is a stable environment, and that is likely to be predictive of what happens as we start getting state relaxation. So no guarantees, but it does seem that that we've arrived at a point of stability in federal drug policy that's reflected in the Cole Memorandum, stating that the government could be enforcing federally, but is not going to. And I think that is going to drive psychedelic policy, and should be something that physicians should legitimately be able to rely upon as we see movement at the state level.
So as we're talking about licensed professionals and the topic of working with psychedelics, Harry, here's the next question for you. What are the risks that psychologists face who offer harm reduction and integration? What are these risks and how can they be mitigated?
I think so. I would say also, likewise for mental health professionals, I think that being involved in whether it's in terms of the business organization or having under your direction and control any direct access to or sharing revenues with the source of the psychedelic is a huge risk issue. But I think there is a wide range of my sense is that for example, the risk from state mental health professional licensing boards is very small with regard to being supportive, coaching, guiding, and taking a role that's facilitating the kind of mental health and emotional dimensions of the experience. But I think the line is that kind of integration into the business is where it gets risky. And
let me interrupt you and say the words coaching and guiding are very tricky in this field. So you're saying coaching and guiding in a classic psychologist way, but not coaching or guiding in a trip sitting way, correct?
Yeah, I think that right. I think you need to be and the problem is for mental health professionals and physicians alike is that you are the most at risk. Right, you're the most vulnerable kind of piece of the puzzle in the sense that these professional licensing boards from state to state, and in particular in states that are more hostile, have a very low threshold to take a disciplinary action against you, to initiate an investigation, and it's incredibly stressful. Right, anyone as a mental health professional or physician or other health professional who's invested so much time and energy into getting a license, and depending on professional reputation, can't afford to be heavily integrated and can't take the same risks that people who don't hold licenses can take. And so I think I really do think that's where the line is. So, right, it does make coaching and guiding of a trip a much trickier thing, because that's all. It's hard to see how you do that, at least in the United States, without putting yourself at risk. Unless the one thing we haven't talked about is the DEA research permit, options, which we do have some clients who are pursuing and are seeing incredible things with. But outside of that environment, I agree. It's that the coaching of a trip outside of a state that actually is going to sanction it is going to be a place where there's so much integration that it's inherently risky.
Hadas, do you have anything that you want to add to that analysis?
No, that was great.
Yeah, and at Plant Medicine Law Group, we draw a pretty strict line in terms of when we counsel clients or when we take on clients, we won't create, for example, legal documentation for an activity that is still illegal. And so there are these multiple gray areas where people want to have some kind of legal package that protects them more, but the underlying activity is illegal. And so that's also a consideration that we navigate, that we can also talk a little bit more about. So next question, what can physicians do to help bring about legalization of psychedelic assisted psychotherapy in their respective states? So this seems to be a question, Hadas, that has to do with governmental support or lobbying support or political support. So what role can physicians play in this conversation?
So I just found out a really interesting and devastating fact. A person cannot run for public office if they are currently or have recently been the recipient of federal funding for research. So what this means is that by design, the people who are in office, and oftentimes the people, making decisions about how these frameworks are going to be created and rolled out, don't know the data. They don't know what the research says. They don't know, what the decisions they are making are actually based on. And I think it's also safe to say they might not be active members of the psychedelic underground. So I think that one of the biggest ways that physicians can be helpful is as educators. So much of what happens on the Hill, of what happens in state agencies like the Oregon Health Authority, DORA in Colorado, is just getting people to understand what this medicine is, what it can do for people, what you've seen it do for loved ones, patients in legal settings, if you have, the context to give that kind of information. And really like reducing fear and stigma. I think that's a big part of it, right? Like taking your expertise and your training. I think that having letters behind your name, for better or for worse, is something that really is, that in and of itself is like very persuasive and comforting to electeds and to regulators. And showing people that this is something valid and this is something legitimate. And making it simple is really helpful. I think sometimes, there's so much information coming from all different parts of the field, and all of it is so interesting and so exciting. But I think what's really helpful, like a congressional hearing, or if you're, doing a lobbying day, is just getting like a one-pager and trying to condense the information into something very digestible, maybe attaching a story to it, something emotionally compelling. And I think also, in a less formal, less structured way, just talking to your colleagues about it. From what I understand, medical training, medical school is pretty linear in its focus, and it's not necessarily the most, responsive, agile curriculum. Like as new research comes out, it's not immediately being updated. And so I think if this is, an area you have interest in, an area you have experience in, talk to your colleagues about it. Maybe you can set up, brown bags where you work or host panels, just things like that, where, you're not asking anyone to make changes. You're just asking people to listen and to consider the evidence, which is compelling.
That's a really good point, that a lot of these topics, cannabis and psychedelics, were not taught in medical school. For most of the individuals that will now be interfacing with people having a bunch of questions about them in legal and not legal states. So how can people legally offer psychedelic integration practices in states where entheogens are not decriminalized? So I think what this person is asking is, how can they act as a therapist, or how can they deal with the aftermath of a psychedelic experience in a state where those substances are not legal, in a way that doesn't get their licensure or get them in trouble?
So I'm happy to take this. So I would say like a sort of building, or maybe building out a little bit more what I was trying to say before. The bottom line is that a physician or health professional can always be present in a therapeutic capacity to ensure that someone is safe. The problem is the facilitation. So how can you do it if your state doesn't decriminalize it? I think you have a few options. One is to actually be, if you're going to be in person, and it has to be in a place that's independent from you as a practitioner, like meaning you are visiting there, whether that's a retreat, whether that's not run by you, right? Whether that's a Native American reservation, whatever space it is, whether you take somebody, frankly, out of the country, which is raises other issues, but is another possibility. You're strictly there as a health professional in a therapeutic capacity to ensure that everybody is safe, and to be able to examine and diagnose and do all the things that you do with your license. So I think that's the important. That's the easiest way to do it. We are seeing the emergence of some telehealth use where the provider is a step safer, in the sense that they're completely remote from the experience, and they're merely interacting with the person going through the experience in a telehealth context. And again, as long as it's a therapeutic capacity, you haven't facilitated, you're merely responding to the fact that this person has made a decision for their own health and wellness to take these substances, that you're not putting yourself at risk in that moment. You're right. And that's, by the way, I should say, and you're not marketing yourself as interwoven. There's a separate marketing and promotion of you as a physician who's familiar with these things, and of the place where the drugs are being used, or the source of the drugs.
And so am I correct in saying that your analysis that you just gave right now contemplated concomitant use of the substance?
Yeah, exactly. Meaning like that. I think that's the key, is that if you are going to be, obviously there are places throughout the country where people can get access to, psilocybin, to all the various peyote, to ibogaine, to all of it. But it can't be that you as a professional are part of the chain and the organization through which it's being obtained, or that you're kind of co-marketing with them. But you can identify yourself. There's no risk to a provider identifying themselves as someone who's familiar with these things and can talk to patients about them, right? You can continue. My view is that we have not seen any state licensing board take any action when a person as a professional is separated from the source itself of the substances.
Got it. And in the context of non-concomitant use, meaning someone went off, used it, and now is back in your office, for example, for pure integration and talking about the experience, it's correct to say that the risk is minimal to none of just being there to support their integration and their thinking through of the experience that they had with the substance on their own.
Correct. Right. Exactly. And in that sense, I don't think that a professional doing that is in any different position than a provider who is working with someone who's taking any illicit substance, right? So that's like that's kind of a to me is a feature of working in the world of addiction and therapeutically as a professional, you have the right to decide how best to treat your patient, going back to the point about harm reduction and there's nothing that is a professionally irresponsible in making a decision that a patient is going to be using these things, and you need to talk to the patient about how to use them, how to think about them. I do think you could be, I come back, we were talking about cannabis as a model, but I also look to opioid regulation as a model. And one thing I'd point to here, I think opioids informed cannabis, and I think opioid and controlled substance regulation by the DEA and state licensing board very much informs how states look at this. So I do think it's worth looking at the models of kind of expectations of working with people from treatment plans and thinking about multiple other modalities. I do think I'm not saying that there's no responsibility as a health professional to have a broader conversation with a patient or a client, but I do think that you can assume it's reasonable to assume that if your patient expresses that they are going to be using these things, and the question is how to do so in a way that advances their health and wellness. You have the right to talk to them about that, and within that context.
And can I just double click on that? Because I'm so happy, Harry, that you made that point. As a practitioner, you have a right to talk to your patient about things that advance their health and wellness. And I also wonder, and this ties back to the question about advocacy and furthering access, expanding access, as in your role as a practitioner. Do we think it's possible that there's actually an obligation to be informed about how to talk to your patients about the substances that they are using? Like whether or not a psychologist is interested in ayahuasca and they want to provide integration services, if their patients are coming to them and saying, I just sat in ceremony, don't you need to know how to be able to talk to them about that? And I think, again, connecting that to the advocacy piece, perhaps one of the ways we can spread education and awareness and start integrating the information about psychedelics and psychedelic-assisted therapy into the mainstream is by saying to your colleagues as physicians, hey, this is stuff that you really ought to know. And it's actually not me trying to convince you of anything or to modify your practice or be for or against anything. But if this is going to come up with your patients in sessions, here are some of the ways that you can talk to them, and like maybe resources you can offer them or places, places you can go in the session that will be beneficial. And to me, that does feel like something that there's a responsibility to do, especially if you're working in the realm of substance abuse and you're aware of, how you talk to a patient about opiates, cocaine, alcohol, things like that. It just seems to me to be sort of, it makes sense.
I could not agree more, Hadas. I think you're making a really important point. And, it's interesting, like I just as an aside, like, I do some work in the world of weight loss. And if you're a weight loss doctor and you're only talking to your clients about phentermine, appetite suppressants, and you're not able to mention that, by the way, there are these new things out there, Wegovy and Mounjaro and these new things, like if today you can't talk about things that are sweeping the country, you're out of step. And so too, I think when we look at like the world of SSRIs in mental health, for example, there was a generation of providers who predated Prozac and all of that who were out of step. And to me, I would actually go, I agree wholeheartedly with what you're saying. And I think if you can't talk today to clients about ketamine, and if you can't talk about the future of psychedelics and what's on the horizon, in a way, you as a provider are limited, and you're not able to reach a significantly growing part of the market, and you're not able to really address the full range of therapeutic options and the way that things are changing. So I love what you're proposing. And I think it goes to this bigger question of what's the standard of care? Like, what are the options, right? Standard of care always when we talk about informed consent, we say, what are the things that the person needs to know? And that's risks, benefits, and alternatives. And I think if you can't speak fully to the alternatives that the person should be thinking about for whatever condition they may be thinking about, they may have to be dealing with, then you're not really you're not at standard of care. And I think that's a great way to bring this into the advocacy piece. I love what you're saying.
I love how the conversation so far has focused on licensed professionals and the tensions that may exist between that reality and the psychedelic renaissance that we're witnessing. The next question goes a little bit in the direction of non-licensed individuals. So here we go. What do we make of the psychedelic coaches and other facilitators? I'm going to add here non-licensed facilitators whom have completed one certification or a weekend intensive and then take the liberty of calling themselves therapists or performing psychedelic therapy. What legal liability does a facilitator like this, who claims to be a therapist but does not hold state licensure, face? So I think there are many things about this question. Where do we want to begin?
So there's a lot to say about this. Therapist is a tricky word, and I think that it often serves as a catch-all. Unlike psychologists, unlike psychiatrists, even social worker, it's actually I think the flexibility around it is part of why it's maybe not so useful, especially in the psychedelic context where people already have so many barriers to discerning what kind of care they're signing up for when they go to work with someone, especially in an underground setting where there is no gold standard of care or certification. And I think, that's part of why I'm excited about the work that APA is doing. We need to crowdsource what that gold standard is, because there is no one group that should decide it alone or in a silo, but there does need to be some sort of, like, for about lack of a better word, consumer protection around what people are getting when they think they're getting therapy. This is where the conversation about state level initiatives and supported adult use comes in. So in Oregon, in Colorado, the models that are being put forth and rolled out are not psychedelic assisted therapy. They're specifically called supported adult use because you are not practicing, none of this is taking place within the medical model. This is all totally unrelated to the clinical trials happening, the FDA. And essentially, the way it's happening in Oregon, what's going to happen in Colorado is that Oregon's going to start accepting licensing applications for facilitators in January, and their main role is going to be like ground control for the mission going on up there. They're just ensuring client safety, right? Like, they're screening for contraindications. They're preparing for clients for the psilocybin experience. They're advising on and signing off on the amount of psilocybin to be administered, but the dosing is going to be something that's determined in the rules. There's going to be like a standard dose. And then they're going to be basically just supervising, holding space, giving non-directive guidance during the psilocybin session. And then, of course, providing integration services. So on the one hand, all of that's like the bare minimum, without saying like you're just going to be a person sitting in a room holding space and providing some type of guidance that you learn in a training program that's like 140 hours. And I think 40 of those are in-person practicum. It's pretty minimal, right? Like, it's not medical school. You're not acting as a psychologist. And I think that there's a lot of mixed feelings around whether or not that's right. I think on the one hand, if you're holding yourself out as a therapist and people think that you are, maybe people don't necessarily understand that you're not a psychologist, you're not a psychiatrist. There's certain issues that you certainly can't make a diagnosis. How competent are you really to screen for contraindications? There's a lot of questions there. And I think that what it's going to come down to is, are the states able to effectively regulate how these services are marketed and what the clients think they're getting? And I think that that's really a question of integrity, right? Like, what are you saying that you are doing? I think on the flip side, the reason Oregon and Colorado and future states they're modeled the way that they are is because it's important to acknowledge that psilocybin, let's just take that as an example, has been used outside of the medical model and out of certainly the therapeutic model, whatever we're taking that to mean, safely, for longer than SSRIs have been used, right? Like safely. And so we have to give credence to that, and we have to respect that, and we can't come in and impose restrictions around practices, around use that rightfully should be able to be experienced in ways that are safe, but not necessarily in line with Western medicine. And so there's a tension between those two things, and we've got to find a way to hold space for both. I think, again, to sort of drill down on what my answer is, I think it's going to come down to being very clear about what it is that you're offering. What does the client think that they're getting? Again, we're trying to put words to an ineffable experience. So there's only so much you can really say about, like, this is what's going to happen to you. But the client needs to be, one, prepared for as much as we can say, these are the full range of possibilities that I can articulate to you about what this experience might be like. And this is what might not happen afterwards. I think it's really important, and it's going to be really important to talk about, here's what this experience might not give you, because especially when people are coming in pretty desperate, it's important to manage expectations that this may not be a catch-all or a fix-all. But again, I think not overselling oneself and one's skill set and one's training. And if anything, like overdoing it, sort of in the way Adriana was talking about at the beginning. One of the things Plant Medicine Law Group does really well is knowing what it does and knowing what it does not do. And I think, we've been in many intake sessions with prospective clients where I think, maybe we could have figured something out, but we err on the side of, no, this is too important for you to think, we do something that we do not do. So just being really clear, and letting people have the information that they need to make informed consent decisions about what they're going into with you as a practitioner.
And one of the things I want to add to that is the difference, different people have different issues or traumas, little t trauma, big T trauma. So it has to be an informed conversation in two directions, right? An individual has to be aware of their historical baggage, their mental health condition, to also understand the different levels of training that their personal situation requires care for. And then an individual doing an intake has to also understand when that person presents issues that exceed their expertise and need to be elevated or delegated or referred to an individual that has the requisite amount of training. So someone who goes to a psilocybin facilitator because they're having a hard time with a breakup, that's a completely different scenario than someone who has had treatment-resistant depression and. And so I think that this conversation about whether psychedelic coaches are sufficient or whatever, I think it goes both ways, right? The individual who needs help, understanding the different hierarchies of services, and then the individuals providing help, understanding when they should not be, just like we as lawyers, when they are not the right fit for the individual coming in. Harry, you wanted to add something.
Yeah, I just want to add a dimension to this conversation about calling yourself a therapist or a psychedelic therapist. And this is not in the context of if Oregon or Colorado establish a framework, my comment now does not apply. But to everybody else who's out there, I just want to point something out, a cautionary note, and I have a little cautionary story to share about it, which is that if you're not operating within a licensing board, like if you are just kind of out there holding yourself out in the wind, then the relevant regulatory authority, if somebody makes a complaint about you and you're investigated, is criminal, right? Is because now you are essentially practicing a healthcare profession without a license. And I wanted to share a story that to me is relevant and is a reason to proceed with caution in this area of using these titles. And more importantly than the titles is what you're actually doing, which is I had a client years ago this was a person who had a PhD in psychology, was teaching psychology at the university level, but never did the clinical hours to be licensed by the state of California as a psychologist. And this person decided, after a while they wanted to do clinical work. So they said, I'll just call myself a life coach. But what they were doing in their practice was very much psychology. They were addressing trauma with clients. They were really getting into heavy duty work and not doing what we think of as life coaching, sort of, which is a lot of working on goal setting and effective communication and stuff that's not the practice of a mental health profession. Anyway, this person, one of the early clients that they saw was a young woman who the psychologist in the life coaching, with air quotes, was said, you're in an abusive relationship with your father. The father was very upset and was very shrewd, and he called the medical board and said this person is practicing without a license, and they also, what people always do, they add things. He said, and they're giving my daughter medication even though they don't have a license. And sure enough, within a couple of weeks, an undercover agent was there and got the doctor to get into a conversation about trauma without a license. And the second visit scheduled, 5 police officers were there, arrested this person, and they were charged criminally because they were outside of the licensing scope. So you have to be very careful. If you're somebody who does not have a license, you want to be very careful about operating outside of an established framework. And to the extent that you get into areas that are not state sanctioned, you're not under a licensing board, you're now in the area where you're talking about district attorneys and potential criminal liability.
I'm so happy that you brought up that story, because it's interesting being in a psychedelics and cannabis law firm. We constantly see individuals entering or in the psychedelic space that simply do not fear the law. And that's very different day to day from our experience with cannabis individuals, where a lot of people are very aware of the law because they've been arrested, or people around them have been arrested, or people have suffered civil asset forfeiture. And I mean, I could go on and on about the racial analysis of why this might be, that so many psychedelic people who are predominantly white are entering this space kind of like without a ton of awareness of, the overlap of criminal law into this realm. So I'm really happy that you shared that story, because it's something that people do need to be aware can happen. So let's talk a little. So I think that this conversation answers actually the next question. Let's check. It said, is it ethical or appropriate for someone who is not licensed, parentheses, not having completed graduate school and state licensure requirements, to call themselves a therapist? Who is legally allowed to call themselves a therapist or a psychedelic therapist? So just to close out this discussion, Harry, the word therapist and who legally can use it, how would we close this out?
I think so. It's a little bit ambiguous, right? Like, the way that I would think about this is the mental health professional landscape is very carved up, right? Psychology is a licensed field, marriage and family therapy, clinical social work, and a lot of states, like here in California, we have this open category of LPCC, licensed professional clinical counselor. So you can call yourself, I could call myself like a coffee therapist or a sleep therapist, and I might be but the question is, am I treading on the line in the territory of a licensed profession with the work that I do? So I think I wouldn't say it's not illegal to use the word therapist, but there's going to be a focus on what you're doing. And the question is, are you crossing lines? And I come back to life coaching just because it's the one area where we've seen, this booming field and all of these mental health professions who are like, hey, wait a second, what's going on here? And these regulators who are very unhappy about it. And there is a carved out space where you can do, there's certain things that are not the practice of these professions. And like I was talking about, goal setting, communication, and so on. But you can't get into that territory. So by the way, I wouldn't call myself a coffee therapist. I might call myself a Scotch single malt whiskey therapist. But I would just be really careful about what you're doing. And when you say psychedelic therapist, it's very loaded. And I think you want to also be in the zone of using free speech, your free speech rights, rather than, look, I want to say I'm grateful for the activists who are taking chances and willing to take the risks to, effectuate the supply that's necessary. But those people need to do so just with open eyes that they are putting themselves at risk in doing so, and to make that as a choice. Somebody has to be willing to do that for there to be any availability. But that can't be. But if you are the psychedelic therapist and you're doing that, you're taking a big risk.
Excellent. Okay. Next one is, what is the legality of charging for services versus determining a quote donation? And Hadas, do you want to take this one?
Yeah, so I can start us off on this one, just maybe by providing some context for the question, because I think I have a sense of what is being asked, and maybe I can make it a bit more clear. At one point, in California, there was a bill that it didn't end up getting passed. I think it might be reintroduced, called SB 519. And SB 519 was going to decriminalize a number of drugs. And one of the things it was going to do was it would have created a beneficial community use model where an individual could not charge for supplying, let's say, psilocybin, which would be decriminalized but not legalized under the would-be law. But they could charge for adjacent services. So, or they could take a donation for adjacent services. They could charge or take a donation. And what this means in practice is, let's say, someone comes to a ceremony and they are administered psilocybin, and there's some sort of facilitation of the ceremony, and then they pay, and what they're paying for is the service of the facilitation, and what's merely being donated to them or gifted to them and is separate from the transaction is the psilocybin itself. So that's something that actually Colorado's new law 122 creates a really similar model where there's no retail market for natural medicines, but you are going to be able to charge for services. I know that's not exactly the same thing, but I did just want to address that piece because it's a question that we get asked a lot. With respect to the question that was literally being asked, what's the difference between a donation and a sale? Technically, I think there's technical things that we could lay out that would distinguish between the two. But as a general rule, when you're talking about a Schedule I controlled substance and you aren't in a decriminalized state, that's not going to make, whether it's a donation or not, isn't going to make a difference. There's some different conversation we can have there, whether if you're a church and you're operating under the auspices of the Religious Freedom Restoration Act. But in general, it's almost not worth getting into because it's not going to protect you either way.
Right. And I think what's interesting to say is that, we are three corporate lawyers. We are not criminal lawyers. Harry, unless you also are a criminal therapist. But I think that it's interesting because, some of these questions are coming in and we know what happens in the underground. And sometimes these questions come in like this one, where it's someone in the underground, most likely in a non-decriminalized state, trying to create risk allocations and trying to say, how can I make my life less risky? How can my behavior be less criminal? But unfortunately, when it comes to substances, for example, in this situation, there's probably not going to be some super nuanced analysis that's going to get you out of a certain type of trouble. Just like a waiver isn't going to get you out of certain types of trouble if the full activity is considered illegal. Yes, Harry.
No, I was gonna say, my partner Mark Hardiman is a former federal prosecutor, so I'm always adjacent to the criminal piece. But what strikes me about, and what worries me about donations is, as a regulatory lawyer, we're always creating contracts and organizational structures, and getting into trying to solve problems that way. But when you are over the line of where criminal authorities, local district attorneys, and the police think that you should be, they are like a bull in a china shop, and they do not care how well thought out that structure was, or how clever that contract was. They're going to look at who's doing this. And so you really need real separation, not just paper separation with things like donation models, outside of the religious context, and that Hadas was talking about.
Yep. And I think the next question is also this kind of like parsing of risk in a situation where it's kind of difficult to do. The question is, can psychedelic facilitators get in trouble? So here, psychedelic facilitators, already an interesting term. Can psychedelic facilitators get in trouble even if they strictly do not offer the substance and do not assist their clients in finding it? And to what extent does this liability extend to people who introduce clients to the facilitator?
I think this,
so here,
this is sort of...
is this a trip sitter, right? So let's be honest, let's be clear. This is not a situation where someone is talking about harm reduction and integration. This question seems to set the stage for actual trip sitting. And the question here being asked, in my eyes, is whether there's a difference between offering the substances as trip sitter, giving you the actual substance, versus you coming in with what you should have for that trip to sitting experience.
So, what I would say, first of all, I do think there is a huge difference. Let me just start with the health professional context, and then the broader trip sitting one. There's a huge difference in the eyes of the law between a self-administration where a person comes with something, and the health professional merely is present in some kind of observing and facilitating, monitoring a role, right? The law distinguishes between, we're not in the zone, when we're talking about anything that's Schedule 1, we're not in the zone of prescribing, because you can't prescribe something that's not legal, but we're in that we can be in that recommending zone, just to go back to the beginning of the conversation, where the professional is using their First Amendment right to say, like, I think it's okay for you to be doing this, right? Or it's good for you to be doing this. And then the other activities that are part of the medication journey, if you will, are number one, dispensing, right? Giving somebody something. That's a very different act. When you give someone something, that's another level of responsibility. And administering it, when you are actually like injecting it, or giving it by an IV infusion or something like that, those are much riskier acts, right? So there is a big, big difference in the eyes of the law if you are merely recommending and monitoring and observing and present, than if you are actually hands-on involved with the substance. And I think I think there's a little ambiguity. The danger is that as that trip sitter, if you will, you are, to the extent that you're promoting and marketing the whole activity in an integrated way, there is a risk that the government, in that bull in the china shop, mentality that I described, is just going to say, we don't really care that you separated out your roles. I think we have it's easier to say for doctors and mental health professionals, because we know that the first line of inquiry is going to be the licensing boards that are going to respect some of that First Amendment privilege But I think it's a little more ambiguous with these, if you aren't really separated. So the more that there's a real separation of how you're communicating, how you message about it. And by the way, here I want to say something that to me is important is when these things get investigated, it's not like the government is going to come to you and say, well, explain it to us exactly how this works, right? They're going to go to the lowest, most available information. They're going to be calling the person who answers the phone. They're going to go to they're going to look for whatever the easiest person to access. And that's usually not you as the trip sitter, let's say. And so, you need to really worry about how everything is messaged and communicated, because whatever the people around you understand, it can undo the best laid sort of separation between the sitting activity and the supplying of the drug. If the person who's kind of answering phone calls for you or talking about it just describes it in an integrated way, that's the way it's going to be perceived by law enforcement. And I think you need to be really, really careful. It's much, much easier if we can say we're going to this place and there's a place that's established that's providing it, and you're truly showing up in a separated way and you're not kind of marketing it all together.
Right.
Something, Harry, actually, you said to me when we were talking about in preparation for this conversation, you mentioned something that I thought was really important, which was that in thinking about what the government is going to look at, you have to think about who these investigators are. They're not doctors, and they don't care about what the best clinical response to anything is. That's just not part of their consideration. Hopefully, ideally, it might inform part of the law and what they're looking at, but that's at the end of the day, like, you can't rely on that. That might be a different situation when you're looking at licensing boards. But when you're talking about law enforcement, that's just not a part of their analysis. And you have to be able to sort of separate the two.
Yeah, 100%. I'm a big believer. I think it's Maslow who says, like, if you walk around with a hammer, every problem looks like a nail. And you see that when you talk to law enforcement, they trained and dedicated their lives to taking on drugs, and you don't get a lot of nuance, right? So I've had conversations at all levels with senior folks at the DEA, with federal prosecutors, and they just don't distinguish all the therapeutic nuance and promise that we on this webinar see. These are not the people who are looking at this and they're gonna just try to use the tools that they have and the mindset they have to fight America's drug problem. That's the unfortunate reality.
Right. And I think that is really important, because what I see happening more and more are individuals using even traditional marketing platforms like MailChimp to send out full communications about upcoming ceremony and donation amounts that are expected. And I can just see where the person writing the email thinks that they're parsing risk in a certain way that follows a certain understanding of the law. And I think what you just said about us thinking about the investigators, if things were to go wrong or be investigated, is very different from, I think, how many times I see these marketing materials by people in the underground being written. So that's also the reason why we at Plant Medicine Law Group don't kind of create legal packages when the overall activity is not yet legal in a certain state. This next question gets us into an
Actually, Adriana,
Yeah.
we are at time already.
Yeah. And I see we have 9 questions in the Q&A still. And I see that I still have, at least 4 in my notes, or 5 that haven't gotten answered. So,
well, can we have you all back? Yeah, we're already asked.
Yes. And I think that what I'm already seeing is, and I can tease out some teasers for next time, is there were several questions about telehealth, which I know is something Harry has thought about and has been wonderful in teaching Hadas and I about the history of dermatology having been the birth of what we now know as ketamine telehealth. We have here questions about people giving advice or talking about themselves and their psychedelic stories on podcasts and how that can be perceived as or could be perceived as giving medical advice. And I think we also have questions about cannabis practitioners trying to understand how cannabis is going to be different from psychedelics. So we could go in more of that direction. We ask for people, we get people asking for advice on how to study and where to learn about these issues. And then there are 9 questions that I will let you, Allie, capture, and maybe we can start with these 9 in the next event. But definitely, let's do it again.
Yes, absolutely. This was the Pandora's box that we revealed lots of great information. I appreciate the expert attorneys here to help us understand this landscape. It's very confusing, very nuanced, and I learned a lot. So thanks so much for being here.